What's up there, beautiful people, and welcome to another edition of Just Trending News. Today we're speaking everything that's related to the Senzo Meyiwa case and the second docket which has just emerged. Obviously, for those of you who do not know, the trial resumed yesterday, which was the 5th of September 2022, and the defense advocate, Adv Zandile Mshololo, is up in arms. So in an application launched on Monday, which was yesterday, Advocate Zandile Mshololo said Judge Maumela should record the irregularities she said had denied her client a fair trial. So basically, this is in relation, as I've already stated, to the case that was opened in 2019. And she's basically saying that the state's alleged failure to disclose the second docket into Senzo Meyiwa's 2014 murder constitutes as unlawful and violates the constitutional rights of Fiso Nduli, who is the fifth accused in the trial. Okay, so this is something, or basically the gist of what Zandile Mshololo is saying. So Nduli, as well as Sibiya Bongani Ntanzi, Tobi Singube, and Mthokoziseni Mapisa, who are represented by attorney T.T. Tobane, face charges of premeditated murder, attempted murder, armed robbery, illegal possession of a firearm, and the illegal possession of ammunition in connection with the footballers' 2014 October murder. Okay, so all five suspects have pleaded not guilty. Meyiwa was shot in Vosloorus in Gauteng, home of his girlfriend, the infamous Kelly Khumalo, in what the state alleges to be a botched robbery. So the state is alleging that this was a botched robbery, but South Africa thinks otherwise. Obviously, there was a Senzo Meyiwa documentary which came out on Netflix. I watched that documentary, and I must say, in my opinion, I do believe that the people that were in the house definitely know something, because obviously, as is being alleged by the Netflix documentary, the crime scene was cleaned before the police actually came, and it actually looked staged. The crime scene looked staged, it was cleaned, the floors were wiped and everything, and there was just a hat that was left there, which allegedly belonged to the robber that was there that night. Okay, so during Nduli's not guilty plea submission in April, Mshololo said her client would exercise his constitutional right to remain silent and not offer a plea explanation to his innocence. Yesterday, Mshololo said had it not been for the non-disclosure of the second docket, which she said Nduli's defense had not been aware of, her client could have given a plea explanation and objected to the charges being put to him because there were other suspects the National Prosecuting Authority had recommended for the charging. So basically, that's what she said. She said verbatim, "It is therefore submitted that the right to a fair trial of the accused entrenched in the Constitution has been violated by failure on the part of the state to provide sufficient information to the defense before any evidence is led." Okay, it is submitted that the state denied the applicant of his constitutional right of access to all information available regarding this case. Further to that, the state denied the applicant the right to apply to the court for an order compelling the state to furnish the defense with information and particulars contained in the police docket in Vosloorus. This is the second police docket, excuse me. She added that the second docket contained an affidavit from Sergeant Thabiso Musia, a forensic expert, and the state's first witness, who allegedly made statements in his second affidavit, deposed in June 2019, had contradicted his first in October 2014. Okay, so basically, ladies and gentlemen, she's saying, or she is disputing, not disputing, but challenging the second docket and saying that this is unlawful and it does not comply with the constitution in South Africa, as she claims that she was not aware of this docket. Okay, however, the state prosecutor, George Boloi, opposed Mshololo's application, telling the court that the defense had been aware of the existence of the second docket first since at least 17 March during the pre-trial sitting, when it was first mentioned in open court. So in that court sitting, I believe allegedly there was her attorney that was present and not actually her, and that's when the first mention of the second docket was made. Okay, so basically, ladies and gentlemen, that is just me giving you a rundown of what happened in court. Tell me what you think. What are your opinions? And I'll see you in my next upload. Goodbye, lovelies.